Judge University.
Okay, great. Now let me try and also share my slide just quickly. Oh, why does it not work? Sorry, just give me 1 second. Here it is. Okay, we've got that. Great. Okay, thank you for that. And thank you to Pam and Alyssa for the invitation to present at this panel and to Mitra for chairing it. So my paper is entitled Judicial Mobilities, Travelling Judges in the Pacific. And it builds on work that I did for my PhD, but kind of takes it in a slightly different direction. So foreign judges regularly sit on the superior courts of Pacific states. So although they're not citizens, they are domestic in the sense that they're appointed by the Pacific state under its own laws, and they sit on domestic courts and they apply domestic law. So as Pam says, just to make clear that we're talking about domestic courts and not international or internationalized courts in this work. So this phenomenon is not unique to the Pacific. Foreign judging arises in some form or another in about 50 jurisdictions, ranging from countries in the Caribbean, Africa, the Middle East, and Europe, in addition to the kind of internationalized commercial courts that Alyssa and Pamela are exploring in their paper. But the Pacific, and in particular the 8 independent Commonwealth member states that I focus on, which are Fiji, Kiribati, Nauru, Samoa, Solomon Islands, Tonga, Tuvalu, and Vanuatu, I think provide a good region to study foreign judging because there the practice is long-standing and it's really entrenched and widespread. So in the 20 years from 2000 to the end of 2019, 210 of the 251 judges, so 84%, serving on the superior courts in these Pacific states were foreign judges. More than 30 of these judges served in more than one jurisdiction, in more than one of the 8 Pacific states. And taking just the most recent year on which I've collected data, 2019, you can see on the slide that the number and the proportion of judges really quite varies across the 8 states. So in Kiribati, Nauru, and Tuvalu, which are all quite small in terms of population, even by small Pacific island standards, all of the judges on these courts were foreign. Tonga and Fiji have a high proportion of foreign judges, while judiciaries of Samoa, Solomon Islands, and Vanuatu have a lower proportion. And I think this is really thanks to efforts in localization in those 3 states. Okay, so one way to think about foreign judges is to emphasize foreignness. And the categorization foreign judge emphasizes the status of the judge as an outsider, whether because they are not citizens or because their legal education and experience is in a foreign jurisdiction. It also invites viewing foreign judges from the perspective of the state that appoints them. So that is the state in which they are foreign. From this point of view, you might want to study the ways in which the presence of foreign judges affects how courts decide cases. You could consider the impacts on the judiciary as an institution, for example, its independence and impartiality. Or you could think about how the use of foreign judges affects the representative qualities of the judiciary and its connections to the state and the community it serves. And I think that's where questions of sovereignty might come in most clearly, in a partial response to Pamela's provocation earlier. But in a spot of shameless self-promotion, these are the kinds of issues that are covered in my book, which will be published next month. That said, the invitation to be part of this panel on travelling judges really made me think about foreign judges from a different perspective, and one that focuses on movement. So movement or travel is a defining feature of foreign judging. Foreign judges move across national and jurisdictional boundaries as they travel from their home jurisdictions to serve as judges in other countries. In this, the field of mobility studies can offer some insights to understand travelling judges. So mobility studies examines the movement of people and objects and ideas and seeks to understand the meanings that attach to these movements and how social concerns such as inequality and power interact with spatial concerns, borders and territory and the like. So framing the study of foreign judges as a study of travelling judges means the comparative unit of analysis is not the jurisdictions that use them, but the judges themselves. And I think it draws attention to at least three aspects of foreign judging. So the first is the modalities of travel. The second is who sits as a judge in the Pacific. And the third is impediments to travel. So in this presentation today, I just want to discuss each of these kind of aspects briefly and present some empirical findings, as well as some thoughts about the meanings that we might attach to the movement of judges. So first, to consider modalities of travel, that is the ways and means by which foreigners come to sit as judges in a Pacific state. So a distinction can be made between foreign judges who reside in the Pacific state and serve full-time as a judge, and those who visit temporarily for a period of days or weeks. So visiting judges or fly-in, fly-out judges might visit periodically, for example, once a year to serve on the Court of Appeal, or only once on an ad hoc basis, for example, to hear a specific case in the Pacific jurisdiction. So already there are different experiences of arrival and departure and return within this cohort of foreign judges. Secondly, foreign judges' travel is supported in different ways. So around 30% of foreign judges in the Pacific, and this is over the last 20-year period, were lawyers recruited from legal practice. So these lawyers are pursuing their legal careers. They're just doing so in a way that takes them outside of their own home jurisdictions. Some settle permanently in the Pacific state, others return home, some move on to yet another jurisdiction. Roughly 25% were retired judges, and many of these sit on courts of appeal in the region, and so they're periodic visitors rather than residents. Around 40% were serving judges, and for judges in this group, sometimes their travel might be a secondment in that it's supported by the judge's home court, for example, through a twinning program or through a MOU between two courts. Other times, individual judges just choose to sit overseas during their annual leave and take time off their full-time home court role to sit in the Pacific. There's also a cohort of foreign judges who are recruited by development programs. So one example is the Commonwealth Fund for Technical Cooperation that recruits and pays for the movement of judges across the Commonwealth. And so this generates not just movement between a judge's home state and the Pacific state and back again, but between a range of overseas jurisdictions in ways that do echo, I think, the movement of 20th century colonial judges across British colonies. So amongst all this diversity, there are some common threads. Foreign judges can be seen as skilled or privileged migrants, people we might call expatriates, who are supported to move and work overseas. Most foreign judges serve on short renewable contracts, in contrast to the security of tenure provided to local judges, who tend to serve until a specified age of retirement. And this not only raises concerns about judicial independence, but in terms of movement, it emphasises the temporariness of foreign judges' positions and also echoes some of the practices of development work where distinctions are also made between local and foreign staff in terms of conditions and pay. Travelling judges are also overwhelmingly male. Only 7% of foreign judges in the Pacific since 2000 were women, reflecting both the underrepresentation of women in the judiciary and also in expatriate migration processes. So this brings us to the question of who travels. So looking at the nationality or country of origin of foreign judges can give us a sense of global hierarchies in the movement of judges. My hypothesis here is that foreign judges predominantly move from larger states of the global north, and in particular from former colonial administrations in the Pacific, namely Australia, New Zealand, and the United Kingdom. A second hypothesis is that the nationality of foreign judges serving in the Pacific is changing as judges are recruited from a more diverse range of Commonwealth countries, including the Global South. Okay, so this chart shows the nationality of foreign judges across the Pacific from 2000 to 2019. And it compiles the proportion of judges of each nationality in each of the 8 states and pushes them together. I hope soon to have the data from 1980 onwards, which will enable us to explore changes over time. But for now, we can see that the proportion of New Zealand and Australian judges, that are shown in the green and the purple on the chart, is smaller in the most recent decade than it was between 2000 and 2009. And in its place, what has grown is the proportion of judges recruited from Asia, which is shown in pink. Now, this result is largely due to the recruitment of Sri Lankan judges in Fiji since 2010, which has its own backstory. I'm happy to talk about it in Q&A, but it is an example of the trend away from traditional donor states, which we can also see, albeit a bit less dramatically, in other states in the region. Okay, so what meanings can be attached to these findings on modalities of travel and on who travels? So the Pacific is a colonised space. Colonial framing characterised the islands as self-contained, as isolated, and sometimes as lawless. On this view, travelling judges brought the law with them when they arrived on Pacific shores. So I'm not suggesting that such views are commonly expressed now, but I do hear some echoes that reverberate into the present. So one such echo, I think, is an emphasis on what Pacific communities lack. So Tongan scholar Epeli Hauofa describes this mindset in the following terms, and I quote here: "The small island states and territories of the Pacific are much too small, too poorly endowed with resources, and too isolated from the centres of economic growth for their inhabitants ever to be able to rise above their present condition of dependence on the largesse of wealthy nations," end quote. These ideas, I think, are echoed in some of the rationales offered for the use of foreign judges in the Pacific. So it's said that these states are too small and their resources too limited to support their own judiciaries, or the community is too small and close for judges to ever be impartial. So the emphasis is on lack rather than what they do have. Hauofa calls for a reimagining of Oceania in which Pacific peoples are not confined to tiny isolated spaces, but in which they travel, taking their worlds with them. And I think that we can see this somewhat in the chart, in the growing cohort of foreign judges from other Pacific states, which is shown in yellow on this chart here. So the size of this group has increased over the last 2 decades and represents movement within and between Pacific states, which is more like a true exchange of judges who are foreign in the sense that they're not citizens, but perhaps less foreign because they're from the region. So an emblematic example is Sir John Murier, who was the first Indigenous Chief Justice of Solomon Islands. And while in this position, he travelled to Vanuatu to hear specific cases there, and also completed a master's degree in New Zealand. In 2003, he resigned his post as Chief Justice to do what one newspaper described as his Commonwealth tour of duty, sitting as a judge in Sierra Leone and then in Belize, in positions supported by the Commonwealth Secretariat. In 2011, he returned to the Pacific, but not to the Solomon Islands. He went to Kiribati to serve as Chief Justice, to Nauru as a visiting Justice of Appeal, and is currently a High Court judge in Tuvalu. So there are other examples of such world-enlarging travel, both by Indigenous judges of the Pacific and judges from elsewhere, which perhaps disrupts that kind of colonial framing that I described earlier. A second kind of meaning that can attach to the travelling judge is as a transnational judicial expert with legal skills that are transferable across national and jurisdictional borders. And I think this emphasis on skills de-emphasises the significance of nationality to the role of a judge. It blurs jurisdictional boundaries by emphasising similarities, such as a shared common law, and glossing differences in and between legal systems. So when judges travel, we can imagine judges not as foreign or local, but as experts in law, adjudication, decision-making, perhaps defined by a common heritage, such as Commonwealth judges, or by the region in which they serve, such as Pacific judges. In this way, the movement of judges can be seen as a way to free judges and perhaps even jurisdictions and laws from the containers of the nation state and national legal systems. That said, and this is my final point, impediments on cross-border movement serve to remind us that the nation state and its borders are still important. So non-citizens, even non-citizens who are judges and chief justices, are subject to restrictions on entry and stay imposed by a state over its own territory. So this sovereign power has been used to remove judges by cancelling their visas in Nauru and Vanuatu. It has been used by third-party states to disrupt judges' travel between their home and a Pacific state, for example, under sanctions targeting Fiji after its 2006 coup. Border restrictions imposed during COVID, of course, have precipitated teleconference judging, but also in some cases disrupted access to justice simply because judges cannot travel. And of course, foreign judges can only serve in jurisdictions whose laws do not require their judges to be citizens, and this rules out travel for judicial service in over 100 states across the world. So while travelling judges might cross national and jurisdictional borders, and in doing so might make these boundaries more porous, these borders have not, and I think will not, completely disappear. So these are my early thoughts on travelling judges as opposed to foreign judges in the Pacific, and I look forward to the discussion to come. Thank you so much.
Thank you, Anna. Now we are going to hear from our discussant, Erin Delaney of Northwestern University.
Thank you, Mitra. Thank you, Pam and Alyssa, for organizing the panel. I was intending to present, I'm working on two different projects connected to judges. One is a project on Namibia, and the other on the Judicial Committee of the Privy Council. And unfortunately, neither progressed to the stage where I can present at this conference, but I am delighted to be able to serve as discussant, and some of the questions that my projects raise, I think, are also raised by the papers today. And so what I hope to do is just draw out a few questions, particularly for Pam, Alyssa, and Anna, and then connect with Mathilde on some of her work and thinking about some methodological issues. So I think Anna's project and Pam and Alyssa's project work incredibly well together because they're asking sort of different questions and yet yet dovetail nicely. So one way of approaching this is, what is it that the courts themselves or those who are constructing the courts are trying to achieve? And in this, we can also look at Roz and Vicky's paper on this topic. What is it that the court is trying to do by accessing this kind of judges? Another way of thinking about it, or what is it that the government or people creating the court are trying to do? That's better phrasing. The other way is of thinking about it maybe from a more first principles question about, is the court legitimate? How do we understand what the judges themselves are doing or contributing? And does that contribute to the court's ultimate legitimacy? So there you have, I think, something that comes out of Mathilde's work, which is, are these courts legitimate? And it's really not a question about citizenship. It's a question about reflective representation, or the representation on the court, and whether or not the people on whom the decisions are resting or for whom the decisions are being made understand that as legitimate. So we have this, then we have the audience. So we have this audience, we have the judges, we have the creators of the court, and all of these different actors within what is essentially a political construct. And I think it raises the question of what is foreign, what is traveling, and does it or does it not matter? And so to sort of make it more complex, right? So Mathilde's issue is that it's not really about foreignness or citizenship. It's about indigeneity, really, to the legal culture at issue. Pam and Alyssa, I'm not sure, it seems to be about who does the group creating the court, who is the audience that group is interested in acquiring, and who is best placed to serve that audience. So you're focusing on traveling judges, but my question for you is, what is the mechanism by which these positions get filled? And does it have to be someone who is foreign or traveling, or is it someone who has been educated abroad? And would that be enough? Or is it about the foreign or travelingness nature of the judges, or is it about signaling because it was someone who was a prior judge? So is what is doing the work the foreignness, or is it the prior judgeness of the individual that might be selling the court to the audience? How do you start to disaggregate that? One thing I think, Alyssa, you might have said was something about, well, they're looking for English law. And maybe if the substantive law has already been committed to being common law, or is it those are just the available travelers? And that's sort of what Anna's piece brought up. Who's willing to travel? Who's interested in traveling? What do those pools look like of the selection pools which are being chosen from? And I don't have a sense of that from your project. So that was a little bit of a question about how far you can go in making claims about what was intended without knowing what was available. And you may have all of that already, but that might be something to think about as you're saying, well, what was intended? What was it? What is available? Who can make up this effort to attract the audience? And then Anna, I think you're sort of moving away from this sense of maybe audience and just really trying to understand maybe some of the substantive content about what is happening. So the law part of what is going on. And that's where then I was wondering from you, well, where's everyone educated? So we know where everyone's from, but if everyone's being educated somewhere else, if you're Sri Lankan, but you're doing the BCL, what does that mean for how you're going to apply law? And I agree with you that this kind of transnational juridical expert skills idea might be too broad, but there still has to be something about legal education. And Mitra maybe can weigh in on this because this is a project that she's working on and something I'm really interested in. How do we weigh legal education as foreign or domestic? And so again, Pam and Alyssa, I thought in your written paper, you mentioned people who'd been trained, somewhere out, and I wanted to know more about, are those really options or not? And that's what made me think of what was doing the work. Is it the foreign training, or is it the fact that this is a fancy person that people might know? But that's very different from a traveling judge. That's sort of like, who are the fancy people available to signal to your audience that this court is legitimate? So again, it comes back to the question of what makes an individual court legitimate in an individual circumstance. Is it reflective representation and indigeneity? Is it an attractiveness to your audience because of your fanciness in terms of arbitral experience? Is it your knowledge of a certain kind of law? And that seems likely to change over different contexts. And so pulling all of that apart might be helpful. In my own project in Namibia, one thing that I'm struggling with, and this goes to Mathilde's just question about what is it to say it's foreign and why does it matter, is there are traveling judges who are non-citizens and educated elsewhere. There are resident judges that are non-citizens and educated elsewhere. And there are citizens that have been educated elsewhere. And then as someone who's interested in judicial behavior and legitimacy, my problem is, well, do I expect everyone to act in similar ways with those different backgrounds? And what does it mean if I'm concerned about political sensitivity to the current government? A resident might be very different from a traveling judge. What if I'm interested in the push of substantive law? Well, then maybe what really matters is everyone who's been educated in Nigeria or in South Africa. And it doesn't matter what their citizenship is. And so trying to figure out how we as a group, or not as a group, but we as scholars interested in this area, start to categorize and pull apart and are very careful about what's at stake in the conclusions we're drawing for the court, for legitimacy, for the substantive area of law. And maybe that overly complicates foreign or even traveling, if you've traveled for your education and then returned. But it's something that I would love to talk about more, as it's something I'm struggling with. So those were just a few questions on the specific papers, and then hopefully some things to talk about. And I hope to include Mitra in the conversation as well as our stalwart moderator. Okay, I'll be quiet now.
Wonderful. Thank you, Erin. I do have many questions, but I'm sure that many other people here do too. So panelists, would you like to respond, or should we just jump in with a bunch of questions and then you can respond to whatever you like? Is it okay if we do the latter, or would you like to respond?
Someone has their hand raised.
Yes, we've got John Wrights has a question. I've got a bunch of questions. Panelists, are you okay if we just jump straight into the questions? Yeah, okay, John.
Okay, well, I don't mean to jump in front of the panelists. It's a very interesting panel. And I'm very glad that I decided to come here. I had no idea what this panel was going to be about. So it's lived up to my expectations. Well, that was easy, but it's been very interesting, actually. But I guess I just want to ask, I don't know why my camera isn't working. I see. I shut it. I just wanted to ask whether you've given some thought to whether these traveling judges work as vectors of transplantation at all. As I thought about that, from what you said, I thought, well, in France, with the French example that Mathilde told us about, it's kind of easy. They're going around the world applying French law, and the theory is it's all the same law. So there's no transplantation there, except maybe there's penetration of the French legal model to these far-flung territories. But and then there was the commercial courts, and I wondered. It sounded like the idea in those commercial courts was that they were taking British common law or some derivative of that as the sort of common basis, and maybe that's what they're up to. But I really wasn't sure what was happening in the Pacific Islands, where I don't even know what law applies, and